Is your local business or organization looking to give back to the community? Help keep our roads clean by joining the Adopt a Road program administered by Keep Tampa Bay Beautiful. Keeping our roads clean is a great way for team building as well as exposure for your business. Select the road your business wants to adopt and dispatch a team to remove litter and debris. Participants will receive 2 signs showing their organization's name as well as safety equipment and instructions for cleaning roads. You can help keep Tampa Bay beautiful by adopting your own road today. To learn more, visit hcfl.gov/cleanhc.
These are the jobs you may not see every day, but just know we're working hard to make Hillsborough County a better place to live, work, and play. Subscribe to our YouTube page for more great county-related videos, only on HTV.
So you have now completed your emergency plan for your family. How about a plan for this family member? Protect your pets during a disaster by including them in your family's emergency plan. Start by making your pet a disaster kit. Put all paperwork into a large Ziploc bag, including a picture of you and your pet, your contact information, vaccination information, and special care instructions. In addition, you should pack certain items to help your pet during the emergency. A 7-day supply of food with bowls, a travel crate, and your pet's favorite toy. Remember, shelters are the place of last resort. Your plan should include being far away from the disaster's epicenter. But if you do find yourself at the shelter, know the rules. Once at the shelter, your pet will be placed in a designated animal section. This is for your pet's safety, as well as other shelter residents. Knowing the shelter rules helps everyone stay safe during an emergency. For more information about shelters, their location, rules, and how to get ready for a disaster, go to hcfl.gov/staysafe.
Good morning and welcome to the November 20th, 2024 Land Use Hearing Officer meeting. I'm Pamela Jo Hatley and I'll be serving as your Land Use Hearing Officer this morning. Before we get started with the meeting, if you will stand as you're able, please, for the Pledge of Allegiance. All right, thank you. And again, I'm Pamela Jo Hatley. I'll be serving as your land use hearing officer this morning. If you have any devices with you today that make noise, would you please take a moment and silence those now? And thank you so much for that. All right, and then I would like to introduce Ms. Colleen Marshall with the Development Services Department. Ms. Marshall will introduce staff, any agenda changes, withdrawals, and also announce the published continuances and withdrawals.
Good morning, Colleen Marshall, Development Services. To my right is Carmen Mason of Development Services staff. To my left is Mary Dorman of the Hillsborough County County Attorney's Office. Alexis Myers of Planning Commission staff will be presenting virtually. During the course of the hearing, a number of other planners will be presenting their findings for various cases and will be introduced for each item. We have no changes to the published agenda. We have a few published continuances and withdrawals today. Item A1, Special Use 240625. The applicant is Harvest Time of Tampa Incorporated. This application is out of order to be heard and is being continued to the December 17, 2024 Land Use Hearing Officer hearing. Item A2, Special Use 240828. The applicant is APC Towers 4 LLC. This application is being continued by the applicant to the January 21st, 2025 Land Use Hearing Officer hearing. Item A3, Variance 241360. The applicant is Carolyn Allen. This application has been withdrawn by the applicant. And item A4, Variance 250002. The applicant is Kendall Signs. This application is out of order to be heard and being continued to the December 17th, 2024 Land Use Hearing Officer hearing. This concludes the continuances and withdrawals.
All right, thank you very much. All right, so the meeting procedures today, first of all, the agenda consists of items that require a public hearing before a hearing master. I will conduct a hearing on each agenda item today and will submit a decision within 15 working days after the conclusion of today's public hearings. My decisions will be filed with the clerk of the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure. I will take evidence, but will exclude evidence that is immaterial, irrelevant, or unduly repetitious. Evidence may be presented in written form. All testimony shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil court action. All right, the order of presentation today will be as follows. First of all, county staff will call the case. Development Services Department will have 5 minutes to present its report and findings. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal and summation. This order of presentation applies to variances. For special use cases, staff will call the case. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. Development Services will have 5 minutes to present its report and findings. Planning Commission will have 5 minutes to present its findings of compliance or non-compliance with the comprehensive plan. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will then have 5 minutes to present any amended findings or comments, and then the applicant will have 5 minutes for rebuttal and summation. The 15 minutes allotted to proponents and opponents is the total time allotted among all speakers. If there are a number of persons who wish to speak on an item, the 15 minutes will be distributed among those speakers. Also, if there are a number of persons who wish to speak on an item, you may designate a single spokesperson to represent your views. When you come to the microphone today to speak, please state your name and address for the record. This meeting is being recorded, so please speak into the microphone clearly so your testimony can be recorded. When you're finished speaking, please see the clerk to my left to sign in for the record. All right, we'll hear from the County Attorney's Office on the legal requirements for appeals of the Land Use Hearing Officer's decision.
This is Mary Dorman from the County Attorney's Office. This Land Use Hearing Officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the Land Use Hearing Officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the Land Use Hearing Officer may be appealed to the Land Use Appeals Board. Should a decision of the Land Use Hearing Officer be appealed, the record evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Land Use Appeals Board. In reaching a final decision on petitions, the Land Use Appeals Board will only consider the decision of the Land Use Hearing Officer and the record evidence, including any evidence from this public hearing. If an appeal is filed, the Land Use Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the Land Use Hearing Officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the Land Use Hearing Officer, presented testimony or other evidence, and is adversely affected by the decision of the Land Use Hearing Officer. It is the role of the County Attorney's Office to ensure that no new evidence or testimony is allowed before the Land Use Appeals Board that was not presented to the Land Use Hearing Officer at today's hearing. The County Attorney will recommend that the Land Use Appeals Board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the Land Use Appeals Board that is outside the record created at today's hearing could jeopardize the legality of the Land Use Appeals Board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the Land Use Appeals Board.
All right, thank you, Ms. Dorman. So all testimony today must be under oath. If you plan to speak today, please stand as you're able and raise your hand to be sworn in. If there are any online speakers, please also raise your hand to be sworn in. All right. Do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. And Ms. Marshall, we're ready to hear the first case, please.
On today's agenda, we have no vested rights, fee waivers, remands, or reconsideration requests, which brings us to Section F, Site Development Variance Requests. Item F1, Variance 24-1254. The applicant is Nelson Gomez. The request is a variance to encroach into the wetland setback. Staff findings will be provided by Wayne Doyen.
Good morning, Wayne Doyen, Development Services. This is variance application 24-1254. Applicant Nelson Gomez, NCC Construction Inc., zoning RC9, location 2413 South 47th Street, Tampa, Florida 33619. Request summary: the applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07.B.4 of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on 10/31/2024, is for the construction of a portion of a new home, AC pad, concrete, and paver driveway within the 30-foot wetland conservation area setback. LEC section 4.0107.B.4, LEC requirement: no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. Variance: 22.3 feet max encroachment into the wetland setback for a portion of a new home, AC pad, concrete, and paver driveway. Result: 7.7 foot wetland setback.
All right, Mr. Doyen, just a quick question for you. And I don't know if staff can answer this, but Based on the size of the parcel and the location of the wetland and the wetland setback area, does it appear to staff that this parcel couldn't, or this home couldn't be developed on the parcel without the variance?
It cannot.
Okay. All right, that's all the questions I have for you. Thank you.
Thank you, ma'am.
All right, applicant, please.
Good morning.
Good
My
morning.
name is Nelson Gomez, 9001 West Norfolk Street, Tampa, Florida, 33615. We're here to ask for an encroachment to this property so we can build on it. We've constructed a retaining wall around to support the erosion and to protect the environment. We initially had submitted for a seawall permit, but was denied by the EPC due to the fact that the existing bridge on the side of on the front of the property was not constructed of a seawall, so we couldn't tie into it. So therefore, we were denied that, and we had to go through the process of a retaining wall through the Hillsborough County, which we did. Of course, now we can't call it a seawall, but we made it with the same structure of the seawall. If you look at the site plan, you'll see the actual seawall around it. And we made that to protect it, and we knew that in the future we were going to have to encroach something, right? Because of the lot size and the septic tank in the rear. And therefore, now that, that's why we're here now. So we're encroaching 22 point, So like Mr. Wayne said, 22.34 on the paver driveway. And as you see, we made the driveway to be paved so we wouldn't obstruct the actual rainfall so it could sip in. So we tried to protect that part right there. But we will need the corner of the house, as you can see right there, is taking like 12.66 feet of it. So that corner and a little bit of the back adds up to about 282 square feet, plus the driveway, which is 207 square feet. And that's what we're here for, to ask for permission to get this variance.
Okay, thank you. And this property is going to be on septic tank then?
Yes, yes.
Okay.
And this is why we couldn't move the house further back, or
Okay.
else we would be cleared if we could. But unfortunately, we can't because of the drain field has to be a specific size.
Okay, so, and I'm looking at your site plan, so the septic tank has to be in the rear of the house, is that
Yes.
correct?
Yes, yes, because
Okay.
if we put it on the side, we can, because then
Okay.
we'll be violating,
All right, then
setback.
also, another question, basically the same thing I asked Mr. Doyen. To your knowledge, would you not be able to build your house on this property without the variance?
Correct, we will not.
Okay, that's all the questions I have for you then.
All right, thank you.
All right, be sure and sign in with the clerk.
Oh, yeah.
Is the other gentleman wish to provide testimony as well, or no? Yes. Okay, thank you. All right, is there anyone here or online who wishes to speak in support of this application? All right, I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, I do not hear anyone. County Development Services, anything further?
Nothing further. Thank you.
All right, thank you. And applicant, Mr. Gomez, did you have anything further?
I do not.
Do not. Okay, thank you.
You got any questions?
No questions, thank you. That'll close the hearing on variance WS 24-1254.
Next item is item F2, variance 24-1361. The applicant is Woodbury Yard LLC and Mixon Woods LLC. The request is a variance to encroach into the wetland setback. Staff findings will be provided by Wayne Doyen.
Good morning, Wayne Doyen, Development Services. This is variance application 24-1361. Applicant Bryce Benson, location folio 06788.0600, 06788.0100, and 06788.0000. Zoning's manufacturing. Request summary. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07.B.4 of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on 10/1/2024, is for encroachment for wetlands A, B, and C for drive aisles and parking areas within the 30-foot wetland conservation area setback. LDC section 4.01.07.B.4. LDC requirement, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. Variance, 30-foot max encroachment into the wetland setback for parking, drive aisles and parking areas within the 30-foot wetland conservation area setback. Wetland A will be 25.3 feet. Wetland B will be 30 feet. Wetland C will be 30 feet. For wetland A, 4.7 remaining setback. Wetland B, 0 remaining setback. Wetland C, 0 remaining setback. Findings, the wetland setback conservation planting area will be reviewed and approved with the construction plans. And number 2, a retaining wall will be provided at the wetland line. This will be reviewed with the subdivision, with the construction plans.
All right, Mr. Doyen, so I did have a question about that after the fact.
Yeah, that was a...
That's a typo?
Yes, it is.
Okay, so this is not an after the fact?
No, it should be for drive aisles and parking areas.
Okay, thank you. Will staff correct that and just put a revised?
Yes, I will.
Yeah.
I'll put a revised copy in the...
In optics?
Yep.
Thank you, and then I can grab it to attach to the decision. Also, I guess same question as before. Would this building, this construction not be possible without encroaching into the wetland area setback?
No, it wouldn't.
Okay, thank you, Mr. Doyen. All right, applicant, please.
Hello, good morning. Bryce Pinson with Half Associates, 1000 North Ashley Drive, Suite 900, Tampa, Florida. Here representing the applicant today. So as staff said, we are requesting a variance to the wetland setback. The site is located at the northeast corner of Falkenberg Road and Woodbury Road. It's 7.45 acres. The future land use is urban mixed use 20, and the zoning is manufacturing, and the proposed use is for an industrial warehouse. The site plan shown here shows the wetland areas in blue labeled A, B, and C. The orange areas are the proposed encroachments into the wetland setback, and the green areas are where we are proposing the planting compensation.
Ms. Pinson, where's that, I believe, a retaining wall? Is that on the north side?
So that would be the thicker black line around A and then the one around B. I address this later, but currently there isn't one anticipated for C, but I'll get to that in a little bit.
Okay, thank you.
So the request is for a reduced setback from 30 feet to 4.7 feet for wetland A and 0 feet for wetlands B and C. History is that EPC authorized wetland impact and mitigation approval on January 3rd of 2022. There are currently approved construction plans showing wetland setback encroachments with pervious impacts and a retaining wall that were approved on March 1st of this year, and that is what's shown currently on this slide. Since then, the owner acquired an additional parcel to the south, and the site has been slightly redesigned to improve the layout for the parking and drive aisles, to which these propose impervious impacts to the wetland setbacks. So the request is to reduce the buffer and conserve the wetland area that has already been conceptually approved by EPC. So as you can see, the buildable area on the subject site is constrained by these wetlands to the north, south, and northeast of the site. There's also a 20-foot immovable drainage easement that runs along the northeast and south of the site, connecting the northern and southern wetland areas. These features are unique and singular to the site that limit the available upland area for the building and associated parking.
And let me just stop you right there too. That drainage easement across the northeast part of the property?
Yes.
I see the dotted lines. So that area is going to be built with a parking lot and so forth. Is the drainage going underneath, or is it just going to be graded to allow for the drainage, or how's that going to be addressed?
That's going to be addressed through the grading, and I think that it also goes underneath. I'm not entirely sure. I can ask some of our engineers, but
Okay, but and the drainage easement isn't being vacated or anything, so that'll be addressed.
correct.
All right, thank you.
So for the Land Development Code and Comprehensive Plan consistency, the subject site, as stated before, has UMU 20 feature land use, which is a max FAR of 0.75. The proposed warehouse is only proposing a max FAR of 0.18. And the proposed uses are consistent in character with the surrounding area and comp plan. The site has the manufacturing zoning district, and the proposed use is already permitted and entitled by the Land Development Code. So here's where we talk about the retaining walls. So they are right now proposed adjacent to wetlands A and B to protect the wetlands and mitigate for any potential impacts. As of right now, it's not anticipated that we'll need one for wetland C because of the grading in that area. However, most of these calculations are preliminary, so once we get more into the construction plans, the orange area shown adjacent to wetland C accounts for a potential need for a retaining wall there. So the proposed retaining walls and wetland setback compensation planting plan will be reviewed through the site construction intake process, as staff stated before. The applicant has worked closely with SwiftMed and EPC to delineate these new wetland lines and provide the approvable impact and mitigation plans. EPC has authorized the wetland impact and mitigation approval as of January of 2022. And there are various site design measures and mitigation measures, such as the retaining walls, being taken to ensure that the wetland areas are protected and the proposed encroachment into these areas don't have a negative impact. And that's all, but I'm here if you have any other questions.
Just quickly, the existing building on the south side, it appears from the site plan that's going away.
Oh, yes.
Okay.
Yes, since they acquired that parcel, that will be going away.
And then same question I had earlier from Mr. Doyen. Is it your opinion that this construction could not take place, these improvements could not be built without the variance?
Yes, it is because of the parking associated with the building and drive aisles.
Okay. All right, thank you.
Thank you.
Be sure and sign in with the clerk. All right, is there anyone here or online who wishes to speak in support of this application? All right, do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, do not hear anyone. County Development Services, anything further?
Nothing further.
All right, thank you. Applicant, Ms. Pinson, anything further? No, okay, thank you. That will close the hearing on variance WS 24-1361.
Next item is item F3, variance 24-1362. The applicant is Patrice Gaeto. The request is a variance to encroach into the wetland setback. Staff findings will be provided by Wayne Doyen.
Wayne Doyen, Development Services. This is variance application 24-1362, applicant Patrice Gaeto. Location 17106 Downs Drive, Odessa, Florida 33556, zoning PD. Request summary, the applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07, point B, point 4 of the Land Development Code. The applicant's specific request, as shown on site plan submitted on 11/6/2024, is for the after-the-fact construction of a building within the 30-foot wetland conservation area setback. LEC section 4.01.07, point B, point 4, LEC requirement, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. Variance, 25.90 feet encroachment in the wetland setback for the after-the-fact building. Result, 4.1 foot remaining wetland setback. findings, a wetland setback compensation planting plan has been provided on the site plan dated 11/6/2024 that provides equivalent square footage of compensation planting to the amount of encroachment.
All right, thank you, Mr. Doyen. Does staff have any idea when this building was constructed?
It's been it's 2013 for aerials. So it's the reason this came up is because they were putting in for a building permit to update it.
Oh, I see. So they submitted a permit application
Yes.
to renovate the building, and this came up.
Yes, ma'am.
But it was an existing building.
Yes, ma'am.
All right. Thank you very much. Okay, applicant?
Hi, Patrice Gato, 17106 Downs Drive, Odessa, Florida, 33556. Requesting a variance into a wetland setback.
All right, Ms. Gaeto. Tell me about the property. When did you acquire it? Was the building already there? And do you know when the building was constructed?
I've been living there since 1998, and I believe the building was there since 2003.
Okay. So it was constructed during the time you were living there?
Yes.
Okay. When you constructed the building, or when the building was constructed there, were there permits pulled for it at that time?
That was all done by my ex-husband, so I had no recollection of that, and I wasn't involved in it. So when I came to renovate it, I wanted to make it it's used as storage, so I just wanted to make it into a workshop. And then I applied for the permits when I realized that, yeah, I think that there was never a permit for that.
Okay, just to clarify that, then, you said it was never permitted for that. Do you mean the wetland impact?
Yeah, I guess code enforcement came out and then
Okay.
told me that what I needed to do, so then I went through the proper way to do it. Yeah.
Okay, all right. So then, just make sure I understand the facts. You've been living at the property since 1998. Is that when you acquired it, or you acquired it with your ex-husband?
With my ex, yeah.
Okay. And the building in question was constructed in 2003.
Mm-hmm.
And you don't have any knowledge of whether there were permits pulled at that time?
No, I had no knowledge because
Okay.
I wasn't involved in it, yeah.
All right. And then you did submit permits to renovate the building, and that is when this issue with the wetland conservation setback came up?
Correct.
Okay. All right, I understand then. Is there anything further you wish to add?
That's it.
All right. Okay, thank you very much.
Okay. Yeah, we went through the homeowners association, so we did get approved for everything there.
Okay.
Yep.
Well, then, question about that. I guess you went through the homeowner association for the renovation, but do you have any knowledge about for the original building?
They did approve it for, yeah.
So you know that they did way back then?
Yeah.
Okay, so you recall that, but not whether there were county permits?
No, because I
Okay.
just went through looking through everything that I had when all this came up, yeah.
Okay. All right, and then if the variance were not granted, you would have to remove the building, is that correct?
Yeah, yes, that would be, a difficult thing for us to do because, it took me this long to save all the money to just do all this and renovate it and everything. And I would like to use it, mostly for my son who's autistic, and then he's homeschooled, so I want to give him a little area to have a quiet time.
Okay.
Yeah.
All right, I understand. Thank you very much.
Okay, thank you.
Okay. All right, is there anyone here or online who wishes to speak in support of this application? All right, I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, I do not hear anyone. Development Services, anything further?
Nothing further.
Okay. Ms. Galleto, anything further? Okay, that's all then. So this will close the hearing on variance WS 24-1362.
We have no signed variance requests, which brings us to section H, variance requests. Item H1, variance 240995. The applicant is Cecilio Rivera. The request is a variance to temporary manufactured home facilities requirements. Staff findings will be provided by Isis Brown.
Good morning, Isis Brown, Development Services. Variance 24-0995. The applicant is requesting to allow a temporary manufactured home while constructing to utilize the existing mobile home as a temporary manufacturing home while the new primary dwelling is constructed. Per LDC Section 61195A, for temporary manufactured homes while constructing, the manufactured home shall be behind the proposed location of the permanent residence structure to be constructed. The variance is to allow for the mobile home to be located in front of the proposed location of the permanent structure that is being proposed to be constructed, resulting in its location at the front of the lot. The second variance is LDC Section 61195C, which states temporary manufactured home facilities shall be screened or separate from public view or view from adjacent properties through use of open space of the distance equal to 1/2 of the lot width required. The required lot width, of course, in the ASC1 and ASC1 zoning district is 150 feet. The variance is requesting a 33.7 feet variance, which will allow for, results in a 41.3 distance setback for the property boundary. The third variance, LDC Section 6.1195C, which is for the same lot width, and that would be for, they're requesting a 48.2 feet variance, which will result in a 26.8 lot width from the property. The subject property, I should say, does not meet the minimum lot width. It's currently 148.9, and so there is an NCL on record 25-0095, which has been placed in the record with regards to this case. And of course, another finding is that if the variance is granted, a conditional use will be sought for this property.
Okay, thank you. I have no questions for you, Ms. Brown.
Oh, okay.
All right, applicant?
Hi, good morning.
Good morning.
My name is Pablo Rivera. I'm speaking from my dad, Cecilio Rivera.
Okay.
So yeah, pretty much.
Mr. Rivera, would you please state your address in the record, and also have your father please state his name and address? Thank you.
Okay.
My name is Cecilio Rivera. I live in 1522 Signet, Dover Road, Dover, Florida.
Thank you.
Yes, and I also live in 1522 Sydney, Dover Road, 33527.
Okay.
We have a little. Can we show this on the?
Yes. You have something to show on the overhead. Just place it on the overhead, and it will come on for you. There you go.
Okay.
And Mr. Rivera, take that microphone and bring it over a little bit, so if you're pointing at the page, I can still hear you.
Okay, so the reason why we want to build so close to the mobile homes because we have a couple of trees back here as well that we don't want to tear down. And also for the driveway, we don't want to extend it all the way back there. But that's pretty much it on why we want to build exactly right behind the mobile home. And the reason why we're building is
Before you go on, can I ask just a question about
Yes.
this survey? The building shown on this survey that you're displaying, is that the existing mobile home?
yes.
Okay.
Yes.
Thank you.
Okay, and so the reason we are requesting permission to build right behind our existing home is to create a more secure home for our children. When there's a hurricane or even a tropical storm, we have to evacuate because we currently live in a mobile home, which is not secure or safe against intense winds or heavy rains. And once our home is completed, the mobile home will be removed. So,
All right. Do you have any idea how long before your home is completed?
it could take maybe a year, so maybe less than a year.
Is it your intention, if this variance is granted and if a special use permit is granted, is it your intention to immediately start constructing your home?
Yes.
Okay. Thank you.
All right.
All right.
That's it.
Anything further?
No, that's it.
All right. I have no questions for you. Be sure and sign in with the clerk here.
Okay, thank you.
All right. Is there anyone here or online who wishes to speak in support of this application? All right. Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right. I don't hear anyone. Development Services, anything further?
Nothing further. Thank you.
All right. And Mr. Rivera, did you have anything further you wish to add? No. All right. Thank you. All right. That will close the hearing on variance 24-0995.
Next item is item H2, variance 24-1157. The applicant is Todd Pressman. The request is a variance to community residential home distance separation requirements. Staff findings will be provided by Michelle Montalbano.
Good morning, hearing officer, staff, Todd Pressman, 200 2nd Avenue South, North, number 451 in St. Petersburg, Florida. This is variance 24-1157 at 618 Valley Vista Drive. The request is reduce the separation requirement between CRHs. 1,000 feet is required. The request is for zero separation for a use that will be 6 or fewer residents. Staff does note during the variance process they did identify another active type A within 1,000 feet at 1004 Pine Grove Drive with an approximate 500-foot separation from the subject property. We are in the Brandon area. We're located on Valla Vista Drive. Currently, at this moment, the same applicant maintains a residence with 6 residents at this location. Today, at 618 Valley Vista is the proposed CRH. So they will be on properties that abut each other, both residential structures.
Okay. The same owner?
It will be the same owner.
It will be the same owner. Okay.
Correct.
Thank you.
So 6 residents currently operating, 6 residents proposed next door. We do have 1 letter of support from across the street noted at this property. And this is the letter in support from that property owner. Community residential homes B and C are specifically pointed out in the code to not be located in a concentration of such as noted community residential homes in an area. That is not specific to type A. Community residential homes housing 6 or fewer residents are deemed a single-family unit and non-commercial residential uses for the purpose of this code. So the type A CRHs are then required to be in a residential structure, aesthetic residential structure looking. So we have that surety that they're small, minimal, non-impacting, aesthetically, again, remaining residential and operate similar to residential. So these residencies uses are quiet. There's no parties, for example, low trips, no loud music, no swim parties, et cetera, et cetera. Now the difference here and uniqueness is that the site proposed is on a corner of 2 streets. So its location is far less and very minimal in terms of impact into the street or the subdivision. Its exposure is to Kings Avenue and Vala Vista versus being interior to a subdivision that is completely surrounded by residential homes. Then additionally, the already approved and operating CRH is located adjacent, which further buffers, if you want to use that word, or shields or reduces exposure of that use. Yet on top of the code recognizing it looks and functions like a residential use. So when we look at the variance criteria, we do feel that that is the unique element of this particular circumstance. There's a hardship that's created by the way a code presents itself on these uses, yet at this site, it is different, the impacts are different, the exposure is different, the buffering and shielding is different. So we do feel that that's supportable in that regard. I did check online just before the hearing. I did not see any letters or communications of opposition. There is one couple here that had some confusion or rumors. They may speak, they may not. We tried to clear that up for them. So in regard to the direction or push at the federal, state, and local levels is to move our mothers and fathers who are retired or need structured help into the community. That's been a push at all levels of government. That's why we allow these uses at 6 less virtually almost anywhere. And in regard to the variance criteria, in terms of being in harmony with the code or being injurious potentially to other property owners, we don't believe that to be the case in the sense of what I presented in terms of buffering, shielding, its locational aspects, harmony with the code, and that the final criteria, going by memory, which I meant to bring the list up with me, is I believe it is the intent, or that it would be, well, I'll leave it as in harmony with you and understand the point I'm getting to. Thank you.
Well,
happy to answer any questions.
Okay, thank you. So based on your testimony and the documents in the record, what I'm hearing is that this is the perfect location for a community residence home right next to another one owned by the same owners and operated by the same owners. It's on a corner lot, and I understand your arguments related to buffering. What I need to hear is what is the hardship related to this property? I understand you did mention hardship in that the code would prevent this property, but we're talking about exactly that, the separation, the separation required. Is there anything you could say about this property that presents a hardship that would meet the criteria in the code?
Well, I have thought about this long and hard, actually for about a week. And what became apparent to me is that we have a code that calls for a 1,000-foot separation. Yet at this particular site, that code has difficulty recognizing a property being expanded to next door, not being expanded, but being placed next door. So on one hand, the code calls for the 1,000-foot separation, yet at the same time, being located, the locational aspects of this site next door to an existing site, which I won't belabor the point, has unique elements, that does create a hardship because we cannot put the structure here. So in that regard, is the locational aspects as how the code recognizes them.
All right. Thank you very much. I appreciate
Thank you.
You're addressing that question.
Thank you.
Be sure and sign in, Mr. Pressman. Thank you. All right.
Good morning, Michelle Montemile, Development Services. The applicant is requesting a variance to community residential home separation requirements to accommodate a proposed Type A community residential home facility. LEC Section 61128A prohibits community residential homes housing 6 or fewer residents, which are considered Type A homes, to be located within a 1,000-foot radius of another Type A home. The proposed community residential home property directly neighbors an existing community residential home to the east. Therefore, the applicant is requesting a variance of 1,000 feet for a 0-foot separation to another Type A home. Staff identified another type A community residential home approximately 500 feet away from the subject property. Because the home is within the variance request radius of 1,000 feet, the second home is also covered in the request. I also just wanted to point out, there's just a typo under LDC requirement. It says 6 or fewer residences. It should be 6 or fewer residents. And that concludes my report.
Okay, thank you for pointing that out. You're going to make a quick correction to that typo and upload a...
We could do that.
All right, thank you very much for that. All right, is there anyone here or online who wishes to speak in support of this application? All right, I don't hear anyone. Is there anyone here or online who wishes to speak in opposition? Please come forward if you wish to speak. And state your name and address first.
My name is Jacob Egan. I'm at 609 Greenbrier Drive in the Ponderosa subdivision. I am going to put some stuff on the Elmo if that's okay. Awesome. So the applicant mentioned or stated a couple of...
And just make sure that you can bring that microphone over. There
Perfect.
You go. Thank you.
The applicant mentioned that there was a previous case back in 2019 on the Pine Grove 1004 Pine Grove Drive. So I pulled that application kind of to start this conversation. And in the findings of fact, this was approved, but I highlighted a couple of sections. You can see actually the radius in the adjacent home at 616, as well as 1004 Pine Grove Drive here. Here we go. Sorry, a couple pieces of paper here. Oop, can't get all the way on there. All right, so in the findings of facts, I highlighted a couple of sections. The intent of the regulation is to protect and preserve the residential character of the neighborhood by ensuring that a proliferation of a community home does not occur. On this page here, it does, again, point out the nearest type A community residential home is located within the Ponderosa subdivision, which is where I live. And it's separated by a collector roadway, Kings Avenue. In this case, there is no separation. It is 0 feet, and with a distance of 610 feet. This case did also point out that the Ponderosa's plat contains 15 acres and only 35 homes. Further, it does state additionally allowing the proposed home will not create an accumulation of community homes within the neighborhood. Obviously, these were separated by 610 feet and not in the same neighborhood. So I think we can point out that fact here. And finally, in the conclusion, it does say, although a slight reduction in the required distance of separation is necessary, that was a reduction request of 390 feet. This is a reduction request of all 1,000 feet.
All right, and just to stop you right there, a couple of questions.
Yep.
So those documents that you displayed, you're going to submit those today, aren't you?
Absolutely, yes.
Okay, thank you. And those are related to the community, is my understanding, related to the community residence home that is not next door to this property, the subject property, but the other one. Is that correct?
That's correct. I just want to show the findings of facts from that
Yep.
previous approval.
Okay. And you live in that other subdivision, not the one where the subject property is that correct?
No, I live in the subject property at 609 Greenbrier Drive. It's one street to the north. It's in the Ponderosa subdivision.
Okay, so it's the same subdivision as the subject property of this case?
Correct.
Okay. All right, go ahead, please.
Yep, I'll submit this to record as well. This is just the petition of opposition of the neighborhood with signatures on it from various addresses of people that live within the Ponderosa subdivision. So I just want to show it on here. So these are all people in opposition to the proposal. Finally, I just wanted to point out, you kind of touched on it earlier in your questions to the applicant, but there's no competent evidence that supports the waiver request. In fact, the application only talks about compatibility concerned and traffic impacts. It doesn't address or provide any detail of why a 1,000-foot separation is required or what hardship may be created. The applicant, again, has failed to articulate that hardship. The application and the request is not unique or singular to the site. If you allow it on this home, you can just continue to allow it down the 35 homes in the entire subdivision. And kind of when does that stop? Something I noted that was interesting too, I understand there can be up to 6 residents. All of the homes in the Ponderosa subdivision were built between 1969 and 1972. They're all 4-bedroom homes, so to get to 6 bedrooms, you have to do things like convert the garage to a bedroom. You have to convert like what would be a dining room into a bedroom to get 6 residents, which is what they've done to the adjacent home.
And let me stop you right there. You say that's what they have done to the adjacent home. Do you have direct knowledge of that? Have you been inside and have you seen it, or have you seen building permits or something?
I have direct knowledge of the garage door being open and a room being built inside of the garage.
Okay. Thank you.
So in conclusion, the applicant's not asking for variance reduction to the 1,000-foot requirement. He's asking for it to actually be completely ignored, to go to 0 feet. There's been no hardship or practical difficulty, and the owner's rights will not be deprived of the rights enjoyed by others in this neighborhood. In fact, I would argue allowing 2 out of 35 homes, this community residential home designation is actually interfering with everybody else. And finally, purchasing a home to create a hardship is completely against the intent, right? The hardship is known before they have purchased the home. So if the applicant goes forward and purchases the home, he's creating a hardship of his own doing, which does not give a right to a waiver or a variance.
All right. Is that all your testimony?
That's it. Thank you.
All right. Thank you, sir. Be sure and sign in. All right, is there anyone else here or online who wishes to speak in opposition to this case? All right, I do not hear anyone. Development Services, anything further?
Nothing further, thank you.
All right, thank you. Okay, there's a member of the audience who's speaking, and I cannot acknowledge you. You're not on the record. You're speaking from the audience. Are you a person in the public who wishes to speak in opposition to this case? If you are, please come forward to the microphone. If not, then I'm going to proceed with the case. All right, so Development Services, I believe you said nothing further. Mr. Pressman, you have 5 minutes for rebuttal and summation. And if your client wishes to speak, we need that on the record.
I'm sorry, I was talking to the...
Okay, I said thank you. We'll hear your summation and rebuttal, and if your client is here and wishes to speak, we just need it on the record. I can't acknowledge them from the audience.
Yes, I did review the petitions, which are all on Greenbrier, which is the next street over. I did see one in Val Vista, but I didn't have time to check that address. So the gentleman who spoke, and spoke very well, and the petitions he brought forward are on the next street north, which are 2 rows of homes, then Val Vista, then this site. So I would suggest, with all due respect, that the impacts of the proposed 6-unit structure, which code defines as residential in use, residential in looks, will have no impacts in terms of the location of those people who brought those forward.
Mr. Pressman, do you recall whether Greenbrier Street was in the public notice distance area?
I don't know. If you give me a minute, I can pull it up and check.
I'll look in my research then. That's fine. Thank you.
Your research tends to be better than mine.
Okay. Thank you. You proceed.
The only other thing I'll add is, as I understand from the applicant, they have been active at their current site since 2014, and he has indicated they have a very good record. He's indicated to me they've had no complaints, which I think relies or places their prior history of the site as being a very well-run site for our mothers and fathers. Short and sweet.
Thank you. And please, sir, state your name and address first.
Good morning. My name is Olusegun Ayeni, 1810 Oak Pond Street in Ruskin, Florida. That's where I live. I just want to say the 616 has been doing the same thing. I mean, taking care of older people since 2014. Although we came there in 2021, I mean, we bought the business, but we've been taking care of old people in that, in 616, which is the next building since 2014, and there's no problem. I don't think anybody even knows what we do. I mean, it is, and then the opposition was saying earlier that it's a 4-bedroom house. Yes, a 4-bedroom house. The state allows us to do, if it's big enough, to put 2 people in the same room, and other rooms could be occupied by single room. So, like we have, there's no addition. It's not like we cry. It allows 6 people. Up to 6 people. So even when it's 4-bedroom, we could have 2 people in the same room. That's if we want to. I mean, if it's big enough, then the other room could be single rooms too. So it's just up to 6 rooms. So that's I want to clarify that.
Thank you. I understand. I appreciate that.
Thank you.
All right. I just want to make sure also, clerk, that that public speaker submitted all those documents and the petitions as well. All right. Thank you for that. Thank you, Mr. Pressman.
Sir, could you come sign in, please?
Also, yes. Mr. Pressman, your client needs to sign in. Thank you. All right, this will close the hearing on variance 24-1157.
Next item is item H3, variance 24-1192. The applicant is Jared J. Fisk. The request is a variance to lots, dimensional, access, and related. We'll present the staff findings. The applicant is requesting a variance of 44 feet to the required front yard setback for ground-mounted solar panels to allow for a 6-foot front yard setback. I'd be happy to answer any questions.
I think my questions I'll have to address to the applicant, so thank you.
Sure.
Thank you. All right, applicant, please.
Hi, my name is Jared Fisk at 8600 Commodity Circle in Orlando, representing Current Home, the contractor on record. So originally this permit was pulled under a residential permit. These plans were issued and approved, and the permit was issued. The placement of the system was basically decided on the shading factors of the property, many large trees. And so this was the position of the solar was chosen for production value, most solar production, energy production per hour of day. Now, when we went to call for, the job is now installed, and when we went to call for final inspection on the project, we were notified that we had the wrong permit. And so we would need to get a variance because the setbacks changed, and we would need to follow the new rule, the new setbacks, in order to get the project approved. I have pictures of the existing system. It's currently 6 feet from the front property line. It's about 6 feet tall. And really unobtrusive.
Mr. Fisk, so the location of this solar array, does it abut, a public right-of-way? Can it be seen from the street, or what's, and I'm not sure of the directions, but maybe it's to the south. What's to the south of that?
There's I think a street to the, I guess to the west.
Okay, I see. I see. Street is to the west.
And then just another property to the front, it looks like.
All right, so this property, where it's situated, is sort of behind another property. Is that correct?
Yes, it looks like it, yes.
Have you been there?
I have not.
Okay, okay. Okay, and so as I understand from your testimony, a permit was received.
Yes.
And on final inspection, you were informed it was the wrong type of permit. Is that because the solar panels were not, for example, on the roof? They were out on a standalone area?
I don't know why they said we had the wrong, they had issued us the wrong permit. We actually produced a full set of plans for review before we were issued that permit.
Okay.
So it was showing them on the ground.
But you weren't informed then that you had to meet the front yard setback until after the permit was issued and you had built the solar array?
That is correct.
Okay. All right, let's talk about then hardships, alleged hardships on this property. Is there anywhere else on the property where the solar panels could have been placed that where they would have been effective?
The solar panels could be placed in other locations, but it would mean removal of very large trees.
Okay, so without the removal of trees, this is essentially the only location on this property where they could be located?
Yes, or it would be very underperforming if we didn't remove the trees.
Okay. All right, so the variance then, in your opinion, is the variance necessary for there to be, in other words, for this property owner to have effective solar, functioning solar panels? They have to be in this location and they can't be here unless the variance is issued. Is that correct?
Optimal functioning, yes.
Okay. All right. I don't think I have any more questions for you. Do you have anything further you wish to add?
No, I do not.
Okay. The documents that you displayed, either make sure that they are in the record already or submit those today, please.
Okay.
And sign in with the clerk right here. Is there anyone here or online who wishes to speak in support of this application? All right, I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, I do not hear anyone. County Development Services, anything further?
Just want to clarify for the record that the subject property, it's accessed through an easement out to Lithia Pinecrest Road. So there is an intervening property between the subject property and the road right-of-way.
All right, thank you for that. All right, applicant, Mr. Fisk, did you have anything further? That's a no. All right, this will close the hearing on variance 24-1192.
Next item is item H4, variance 24-1200. The applicant is Omar Saleh. The request is a variance to sidewalk requirements. Staff findings will be provided by James Ratliff.
Hello. This is James Ratliff, Principal Planner with Transportation Review Section of Development Services for application 24-1200. The applicant is seeking to waive the sidewalk required along their Morrisbridge Road frontage. Specific sections sought to be waived include multiple subsections of Land Development Code section 6.03.02, specifically subsections A, C, D, G, and H. Attached to the staff report is included the site plan provided by the applicant, as well as the sidewalk implementation protocol approved by the Director of Development Review sitting in his capacity as county engineer. This protocol provides additional detail for how the administrator interprets relevant sidewalk provisions to determine when sidewalks are required. Additional design detail regarding sidewalks is governed by the Transportation Technical Manual. As we do for variances which affect transportation-related life safety issues, staff has issued some findings with respect to the applicant's application and responses to the variance criteria. Staff found that the applicant failed to meet multiple criteria specified in the staff report. I did want to point out that there was an error in the staff report in the 5th and 8th findings. The Land Development Code section that specifies what applicants are required to do in the event that the right-of-way is too small to accommodate a required sidewalk should have read section 6.03.02.d. We will be revising that, placing it into optic shortly. And with that, I'm available for any questions you have.
Could you repeat those corrected LDC sections, please, Mr. Ratliff?
Sure, yeah. It was in the 5th and the 8th finding in the staff report, and instead of reading, I believe it said 6.02.02d, it should have read 6.03.02.d. Okay, thank you. And I know you're going to place a corrected staff report in the record, but I just wanted to make note of that. Thank you for that. Yes, thank you.
Don't have any more questions for you. All right, applicant.
We reside at 10804 Breaking Rocks Drive. The property address in question, 15290 Morrisbridge Road, was currently a vacant lot where I'm currently building a single-family home for myself and my family. I am the owner, the architect, and the contractor at this site. I submitted for a permit application for new single-family development beginning of 2022. Permit was approved sometime mid-2023, and I began construction December 2023. I broke ground. Going back and forth with local plan reviewers, they came out and did a site survey. They deemed that a sidewalk was required. At the time, I asked a question about the ditch, because there's currently a EPC they call Water of the U.S. easement, where the approved sidewalk was permitted to be located. About 6 months ago, I had a county representative and inspector come out and do a courtesy walkthrough because I had some concerns about placing a sidewalk in the approved ditch where I cannot, which is also a wetland setback and a wetland area. The inspector came out and he agreed with me that a sidewalk cannot go in that location. The ditch is not to be altered or modified in any way. And I was...
Mr. Solly, you say an inspector. Was that a Hillsborough County building inspector, or was this someone from EPC?
Hillsborough County building inspector.
Okay.
I do not recall his name at the moment, but
okay.
He came out, did a courtesy walkthrough, and he did agree that a sidewalk cannot be placed in the ditch area right off Morrisbridge Road, as it's protected wetland, and he suggested that I apply for this variance. So if I could just share some information on the overhead projector here. I have some documents that I've printed out.
All right, use the overhead projector and make sure you bring the microphone over so I can hear you. Thank you.
So the first one here is the site plan. I don't know if we can zoom in here or not. Okay. So you can see here, Morrisbridge Road runs north-south to the west side of the property. Let me try to zoom in here a little more. So you can see this hatched dark gray area along Morrisbridge Road. That's all the protected wetland area that was surveyed by EPC. And the sidewalk is this darker gray line, which is outside of my property line as dictated by some of the plan review comments I received. And it clearly falls within that wetland setback. And there's a site section.
Okay, before you move that,
Yep.
Put it back up there. I want to make sure I understand what you just said. All right, so on this survey that you're displaying, where the little box is that says Morrisbridge Road, so on my screen, to the left of that, there's a line. What is that first line there?
The red line?
No, the black line.
Okay, the dark black line there by Morrisbridge Road, that is the street. That's the edge of pavement.
Edge of pavement, okay. And then going left from there, what's the red dot line?
So the red dashed lines with the radius Oh, the first red dashed line, those are the topography lines.
Okay, so that's
within
the
wetland.
elevation
Yes.
topography?
Yep.
Okay.
And then you see the dashed lines going north-south, and then you see the radius of the driveway. So the dashed lines going north-south, that's the approved culvert location that's been installed.
Okay, just a second. Then there's okay, I see the two dashed lines that run together. That's the culvert.
Yeah.
Got it.
Yeah, right there.
And then, so going left on the screen from there's a dark line and then a gray area and another dark line. What is that gray area between those two dark lines?
That was the approved location of the 5-foot sidewalk.
So there's on the plans, there's a sidewalk shown there.
Correct.
Okay, so then there's some white area, then there's another, looks like a dark line, and some lighter gray area. What's all that?
So between the dark line adjacent to the dark gray area and the dashed line and the hatched gray area, that's property outside of my property line.
So this plan shows a sidewalk outside your property line.
Correct. Adjacent to the right-of-way.
Okay. And so this was approved in your permits?
This was approved, yes.
Okay, so a sidewalk could go there?
On paper, but not in reality.
What prevents it?
I have some images here of the actual site conditions, and I'll show those next.
And okay, so my question is, why can't the sidewalk go there? But also, what is that light gray area or the hatched gray area, as you called it?
That's the wetland area within my property lines.
Okay, and it is an actual wetland area?
Correct, yep, that's been surveyed by EPC.
Okay, thank you.
Now, there's a site section that we put together. So these trees are a little larger on paper than they actually are in real life, but there is pretty heavily wooded on my property line off of the edge of pavement within the wetland area in the ditch. So this area right here, that's where the sidewalk has been approved to be installed, which is clearly in the ditch area, and there's a slope that's greater than the approved code for accessibility.
So where you've got your finger,
Yes.
you just said that is in the ditch area, but on the other part of the survey, it was it looks like to the east of the ditch area?
It's in the ditch area. So even on the site plan survey, the dark gray hatch area is in the ditch area.
Well, I mean, it looks separate. I see the light gray area. You said that's the wetland.
Within my property line, yes.
Okay, is the wetland and the ditch area, is that two different things?
No, that's all one. So from this red line here within my property line, and this red line adjacent to Morris Bridge Road, that's all been deemed wetland by the EPC.
Oh, okay, so because you just testified that the light gray colored area is the wetland area.
Within my property line, correct. Outside of my property line, it's not hatched, but it is still indicated by the dashed red lines.
Okay, do you have a wetland survey?
Not with me, but I do have one, yes.
Is there one submitted to the record?
Only if it was required to be submitted.
So have you been informed by the Environmental Protection Commission or the county that you cannot put a sidewalk where it is shown on this site plan right here?
Yes, I have.
Who has informed you that?
I have a letter from the EPC stating that no alterations to the wetland area are permitted aside from what has been approved. And what has been approved was the driveway entrance and the culvert.
Okay, but I have nothing in the record that shows me where the actual wetland is, other than what you've just testified, that it's in the light gray area here, but then you're saying that there's more wetland than just that, but I have nothing that shows me where that wetland is.
I've stated the wetland within my property is a light gray area, but the total wetland area is between the two red dashed lines within my property and adjacent to Morris Bridge Road. That is the entirety of the wetland area. The light dashed wetland area is only what is within my property lines.
And does this survey show that? I mean, it's not big enough for me to see it here, but does it show that?
There's an indication of where the property line is, And there's indication of what is considered, it's kind of small up here, but
Is the top of the page to the north or to the south?
north.
Okay, so the road is on the east of your property.
Correct.
Okay. So are you saying that the wetland area goes into the public right-of-way?
It does, yes.
So essentially, there's a road built on it?
I can't testify to that.
Okay.
Yeah, where the road is not, it's outside of my property line, and I haven't investigated that thoroughly enough.
Is there anything in the record, I mean, other than your letter that says, from the EPCs, that says you can impact the wetland with your driveway?
Correct.
Is there anything in the record that says, oh, but you can't build a sidewalk here?
Not in those direct terms, but I do have emails from the plan reviewer saying I cannot alter the ditch. And as the ditch is now with the current slope, it does not conform to ADA requirements.
And the ditch is the light gray area?
Within my property line, yes, but it does extend to Morrisbridge Road. And I have photographs of that I can present as well.
Okay, that would probably be helpful.
Yes, let me switch these.
Thank you.
So this being looking northbound on Morrisbridge Road, the red hatch line is where the proposed sidewalk was approved to be located. And you can see it's heavily wooded, and there's lots of trees there, and it sits within the ditch area.
Okay, go
This
ahead.
image here is looking into the driveway area that has been constructed, or as a construction entrance. And the red dashed area again is where the proposed sidewalk was approved. Again, going through the ditch area, you can see the sloping there, and you can see the trees in that area. And to construct a sidewalk there, those trees will need to be removed.
And those are off of your property?
Correct.
Okay.
This image also shows a closer view of where that sidewalk has been approved to be constructed. As you can see, it is in the ditch area, and also those trees need to be removed in order to install or construct the sidewalk. And those trees are outside of my property line.
All right, I'm seeing, it appears there's a driveway that would be probably to the south, where just in front of that sign. So there's a driveway that crosses across that, I guess, that ditch, and it appears to be there's a culvert there.
Correct. That is my neighbor's property. That's not my property.
Okay, I see that. And so from this picture, based on this picture, the sidewalk then is required to be, it would fall basically to the west of your neighbor's culvert.
Yes, correct.
Okay. I mean, it would intersect your neighbor's property on west of that culvert.
Yes.
And that indicates, or does it indicate basically where it would fall on your property as well?
Correct. If you take a straight line from culvert to culvert, it would fall on the west side of where we currently have the culverts installed.
Okay, thank you.
And this is an image of kind of from inside of my property. So the that's, what happened there? Okay, thank you. So the red dashed line is where the top of ditch and top of slope is. And what I did here was the county inspector recommended that I show what it would look like if I brought the sidewalk into my property. And even still have a similar condition as the top of slope to the ditch falls within the property, the sidewalk would still be in the ditch area, and I would still need to remove a lot of the trees in order to construct the sidewalk. So the main concerns here are putting the sidewalk in an EPC dedicated wetland area. And number two, most of those trees do need to be removed in order to construct this sidewalk. And those trees also fall within the wetland area. And they also provide a buffer zone between the street, which is highly vehicular traffic, and my private property where I am constructing a single family home for me and my family and my children. So there's a safety concern for me if I bring that sidewalk into my property on higher flat ground. And then also the code section states, so the code section 6.03.02 sidewalks states that sidewalks shall be required in all land use categories where necessary to provide for safe pedestrian circulation and shall be constructed within the right-of-way until the end of the section. Currently, Morris Bridge Road is not used for pedestrian traffic. The most pedestrians you see are on bikes, and there's not even a bike lane, and I can probably have 100 people here to say that road is not safe for pedestrian traffic. So whether a sidewalk is installed or not, having a sidewalk on Morris Bridge Road as it is currently constructed is not safe.
All right, Mr. Sally, you testified that you're the owner of this property?
Yes.
And also the architect?
Yes, and the contractor.
Are you a professional architect?
I am.
Okay. Then, speaking as an architect?
Yes.
In your professional opinion, is it impossible or impracticable to put a sidewalk on this property as required by the county?
It is impractical, yes. Impossible, no.
What would make it possible?
You have to remove a large amount of trees. I don't have the exact number. There's a combination of oak and maple. Some of them are larger than 10-inch diameter, which will require a tree permit to remove. The existing wetland will need to be regraded to create an ADA accessible slope for the sidewalk. So there's some work that would need to be done before a sidewalk can actually be constructed in that area.
And would that require, what you just mentioned to the wetlands, would that require an EPC approval?
I cannot confirm to that, but I would assume so.
You would be impacting wetlands?
It would be, yes.
Okay. What would accomplish if you built a sidewalk there would just be that there would be a sidewalk in front of your property?
Correct. It does not connect to any adjacent properties, as the adjacent properties do not have sidewalks.
Do you know where the nearest property is where there's a sidewalk?
Quarry Lake Isles, which is a development just south of me, maybe 200 or 300 feet away. And then there is a park development that has been constructed. I measured it. It's over 850 feet away from my property.
Okay.
On that side of the right-of-way.
On that side of the road?
Correct.
Okay. All right, thank you. Any further questions or comments you would need to make?
That's all for me. Thank you.
All right. Be sure and sign in with the clerk. And Mr. Saller, everything that you displayed on the overhead today, please make sure that you submit it to the record with the clerk. All right, is there anyone here or online who wishes to speak in support of this application? All right, not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, I do not hear anyone. Development services, or anything further? Or transportation?
Yes, ma'am. I did want to just point out on that site plan that was shown up on the Elmo, there is a notation to the wetland that was shaded, the one that's outside of the right-of-way. And it states wetland is exempt per EPC review and then provides number 76841. Our understanding is that that means that EPC is not claiming that as a wetland and that impacts to that are permissible. Again, even if it was a wetland by some stretch, again, wetland impacts can be authorized and are for roadway construction, and sidewalks are an integral part of roadways. And so typically that is something that can be authorized for exemption. But if that was something that the applicant desired to avoid, again, that section of land development code allows them to kind of bend that into their property to meander that sidewalk to avoid wetland impacts. And so there are multiple options here, but I did want to just point out that about that wetland exemption that's shown on the site plan.
All right, and just a question about that, Mr. Ratliff. So the code would allow, well, first of all, where the county is requiring, the county's requiring a sidewalk, but the county isn't requiring that it be in the right-of-way or not. Is that correct?
That is correct.
So the code would allow a sidewalk to be on the property owner's private property?
Correct, and provide an easement to the county, or at their sole option, they can choose to dedicate the underlying fee. But yes, that's what the 60302D portion of that land development code states, that in the event the right-of-way is too small, that could either be because it's physically too small, or maybe because there's an obstruction like a wetland that you couldn't permit, or a ditch that you're trying to avoid. And so if there was additional right-of-way needed to accommodate that sidewalk, then it would be the applicant's responsibility to provide that.
So the county would require the sidewalk, and if it can't be on the right-of-way, it could be on the property owner's private property, and the county would require an easement, or that property be dedicated to the county, correct?
Correct. We would never require the dedication, but that's something we allow as an option to the easement. But the land development code only requires them to provide an easement for public maintenance and access purposes.
Okay. All right. Thank you. Applicant, any rebuttal or summation?
Yes, on the note of the exemption, to my understanding, the exemption was only for the driveway and the culvert and the removal of select trees where the driveway is going.
Well, wait a minute. Exemption, do you mean from the EPC?
Yeah, the EPC wetland exemption that the gentleman stated was on the plans.
Okay, wait just a minute. We're talking on top of each other.
Sorry.
All right. Is it an exemption, or is that the EPC approved impacts?
I'm not sure.
Okay.
But yeah, per the gentleman who just spoke, said there's an EPC exemption for the wetland. To my understanding, and my understanding of the letter that was provided to me by the EPC, the exemption was only for the driveway and the culvert and the removal of select trees within the driveway area, not the entire wetland area.
Okay. All right. Did you submit that in the record?
I did not.
Okay. All right. That's fine. All right. Thank you. Anything further?
That's all for me. Thank you.
All right. Thank you. All right. This will close the hearing on variance 24-1200.
Next item is item H5, variance 24-1233. The applicant is Donald Ray and Rachel Ann Polson. The request is a variance to lot development standards. Staff findings will be provided by Tanya Chappella. Sir, the
Development Services, wait just a second. We'll hear from Development Services first, please. Thank you.
Tanya Chappella, Development Services. The applicant is requesting a variance to accommodate the proposed accessory structure within a front yard functioning as a side yard on a corner lot. Per the Land Development Code, Section 61104C4 and 60101, on any corner lot, no part of any accessory structure shall be located in the required front yards, except where one front yard functions as a side yard. On these lots, accessory structures shall be permitted to intrude up to 10 feet into the required front yard functioning as a side yard. A minimum front yard setback of 25 feet is required in the RSC 6 district. Therefore, the required minimum setback for an accessory structure where the front yard functions as a side is 15 feet. The applicant is requesting a 5-foot variance to allow a 10-foot front yard setback for an accessory structure on Buckhorn Oaks Drive. And this concludes my presentation.
All right, thank you. Now, applicant, please, we'll hear from you.
Good morning. My name's Donald Polson. I live at 2715 Mock Orange Court in Valrico. And the information here shows we have a 0.76 lot acre. It's actually 0.37. If you see on the diagram here, these county owns a 12.5-foot strip all around our property. I wasn't even aware of that until I came up. I've lived here for 9 years, and we wanted to build a attached garage. Our existing garage there on Mock Orange Court on the north there, it's a 2-car garage, and to the west of it, there's a 25-foot line between the house and the side neighbor's yard, so there's not enough room to even add a 3rd car onto our existing 2-car garage. Over to the east side of the property, if you look from the yellow home all the way out to the street, it's actually 50 feet. If you go way out there, it's 50 feet. And then when I started this process, I realized there's a 12.5-foot strip that's owned by the county. Then there's a 10-foot easement for utilities and drainage. So my request is, as you see in the pink area, we'd like to build a 2-car detached garage. It will be built of the same construction as our home, with stucco finish and composite shingle roof. And it would have a 22.5-foot driveway from the street into where the beginning of the building would be. Our request is to start the edge of the building there, just on the west edge of the easement, not on the easement, but beginning at the easement.
Okay, and it's hard to tell from your survey there, but is this going to be an attached structure or a detached?
It's going to be detached by 2 or 3 feet. The way the home's built, I don't have drawings of the home, but it would be very awkward to actually attach it to the house. Okay. It would look odd if it was attached to the home. If you note, let me point right here, if you can.
Oh, there you go.
Our septic system is sitting right where that word lot 1 is.
Okay.
That's where our septic system is. So I can't attach to the home on that side. I'd have to, I don't know where we'd put the septic. We'd have to move the septic to the very back corner of the yard or something. It would cost more, money than it'd be worth to move the whole septic system. So that pink area is really the only area in my property to put a 2-car garage. At the back of my property, there's a pool fence, and it's about 25 feet. And on the west side, there's like 25 feet. So there's not room on the west or the south of our home to put another garage. But our neighborhood typically has 2-car garage homes in it, and so we all have cars parked in the garage. And in the driveway, we actually own 4 cars, so I have 2 in the garage and 2 in the driveway, and this will allow us to have all of our cars inside of a garage.
Okay. So then, just to be clear, because of the size and shape of your property and the way it's already developed, and with your septic tank and everything, is it your testimony that there's no other area on your parcel that you could place this detached garage?
That's correct.
Okay. So without the variance, you couldn't build it?
That is correct.
Okay. Thank you. Be sure and sign in with the clerk.
Thanks.
And make sure you submit the item you displayed.
It's been submitted.
It's been submitted to the record already. All right, thank you. All right, we have that in the record. Okay, is there anyone here or online who wishes to speak in support of this application? All right, I don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, I don't hear anyone. County Development Services, anything further?
Nothing further.
All right, thank you. Mr. Polson, did you have anything further to add? No, all right. That will close the hearing on variance 24-1233.
Next item is item H6, variance 24-1285. The applicant is Todd Pressman. The request is a variance to the distance requirements of an eating establishment's order box for drive-through service from residentially zoned property. Staff findings will be provided by Chris Grant-Leonard.
Good morning.
Morning.
Chris Grant-Leonard, planner with Development Services. I'm here to present variance 24-1285. The applicant is requesting a variance to reduce the distance of a proposed order box for an eating establishment from a required 200 feet to 91.35 feet on property zone PD. The request is for a variance to the LDC section 6.11.35.b.1. The requirement is no order box used in the ordering of food or beverages from a drive-through window shall be located within 200 feet of any property zoned residential. The applicant is requesting a variance of 108.65 feet, which would result in a 91.35 feet distance separation from the order box for a proposed eating establishment to the residential zone property. Our findings are the subject parcel is located in the State Road 60 Brennan Boulevard Overlay District. That concludes my staff report. I'm glad to answer any questions.
I don't think I have any questions for you.
Thank you.
All right. All right. Applicant?
Good morning, Hearing Officer Todd Pressman, 200 2nd Avenue South, number 4, 51 in St. Petersburg. This is variance 24-1285 in the Valrico area, 0.76 acres. This is the site as shown just immediately north of East State Road 60 at the corner of Mulrennan. The issue is to allow an order box for an eating establishment and 91.35 feet where 200 feet is required from residential zone property. So the variance is for 108.65 feet. This is a part of a long-time zoning. That most recent was PRS 18-0312, upon which the variance site was one lot or one area of that whole zoning element, which the main building, which is not existing, was proposed on East Road, was proposed on 60. There's an internal private road, and then the site again is indicated. There is another lot which is located adjacent to the right. Now, there is one condition that is very specific and is very directive, which is that access to the out parcel shall only be from drives internal to the shopping center. And that is followed through on all of the conditions through all the many different forms that this zoning application has taken. And shown here again in terms of the commercial component. So the site being located on this internal access does have significant impacts as to where access is going to be and how circulation is going to occur on the site.
Okay, then just a quick question for you right there, that one. So based on that prior zoning approval, then am I understanding this correctly, that access to the subject property has to be from that private drive to the south?
Correct.
So it cannot be, in other words, from Mulrennan Road?
That's correct.
Okay, thank you.
So beyond that element, as we tried to make this as compatible as possible, we added a restriction that the north half of the property would be restricted from a menu or order board. To the north is residential. So as we looked at the access points and how circulation would have to occur, we found or determined that the menu board should be able to exist in the south half, which then gives us a good buffer shielding restriction on the north half of the lot.
So this, could you go back to that prior slide, please? Thank you. This property is essentially square in shape, right?
Essentially.
Okay. And then from the distance from the south property boundary to the north property boundary adjacent to the residential, that distance, based on this survey here, looks like it's 182 feet. Is that about that? So the property itself altogether isn't big enough for a 200-foot distance for an order box to the residential property. Is that correct?
That's correct.
Okay. And your client knew that, of course, when they acquired the property.
Yes.
And
Well, I would say that situation, circumstance was certainly existing.
okay, whether they had personal knowledge of it or not, that was the land development code existing at the time.
I think what you're getting, with all due respect, to take a jump, prior knowledge, certainly something that folks look at in terms of hardship and such, but I've never seen prior knowledge in the specific criteria, just to throw that in if I may. Just for good measure.
Well, boil the question down to, there's no place on this property where they could put that order box where it would be 200 feet from residential property. Is that correct?
That would be my understanding, yes.
Based on the length of the property or the width, the depth of the property of 182.7 feet.
Yeah, I mean, I do believe that's generally true. The only thought I'm having at the moment is if, yeah, because that property line in the north, yes, correct. So I would agree with that, sir.
I'm just looking at this slide you're displaying right now. The adjacent property on the north, it says tract E3 common area. What is located there? Is that a residential?
It's multi-residential.
Okay. So where that common area is it parking area or?
It appeared to me that it is a required buffer area.
Okay.
I just recall as I was reading through the zoning conditions, that's what I recall.
Okay.
And I do think I have a photo of that area coming up.
Okay, thank you.
Continue. Thank you. Okay, so our determination is that the circulation and access from the internal drive is either going to be to the left or the right. It's going to have to be that southern part. So with that configuration, it certainly appears that the order box in either configuration would have to be pointed away from the northern property line or the residential to the north. So that orientation we can definitely secure in terms of the condition that controls access, and then that in turn controls circulation, and in turn controls the orientation of those boxes in either direction. We'd like to add a restriction, which is similar to conditions in the zoning order already, that the order box be shielded and surrounded with landscaping material on all sides. There's a similar condition in the zoning for other elements like mechanical and things of that nature. Now, there already is a substantial existing buffer that is many times exceeding the code on the north. As you can see, this is a shot from the internal roadway looking at the site. And then, as per your questions, this is on Mulrennan. To the right is the site. To the left is the existing multifamily residential. So you can see that there's a substantial buffering that is many times above and beyond what would be required for code. So when we look at the criteria are a hardship is created by the condition in zoning, which then moves us through the points I presented in terms of circulation, orientation of the box. We feel that those elements provide a shielding and buffering in regard to potential impacts and allows the site to be in harmony with the code. I did check online just before the hearing. There were no letters or emails of objection. So we've been able to establish that neighbors to the north have not responded. So we feel that with the elements we're presenting, with the restrictions, that it does meet the intent of the code and will allow the site to exist considering the difficulties and the uniquenesses of the elements coming together.
All right, thank you. I have no further questions for you. Oh, did you need Mr. Pressman to sign in for that one? Thank you. All right, is there anyone here or online who wishes to speak in support of this application? All right, don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? I do not hear anyone. Development Services, anything further?
Just want to mention for the record, in the 61135 B2 does require a solid screening fence or wall, minimum 6 foot in height, between the property that's used for the drive-through facility and the properties zoned residential. So that would still be required as well.
Okay, thank you. All right, applicant, anything further?
Yeah, just to state in regard to noticing, we did notice 30 people separately, and of course, the big yellow sign has been up for quite some time. Thank you.
All right, thank you. This will close the hearing on variance 24-1285.
Next item is item H7, variance 24-1300. The applicant is David Higuera. The request is a variance to lot development standards. Staff findings will be provided by Logan McCaig.
Morning, Logan McCaig, Development Services. This is for variance 24-1300. The applicant is requesting a variance to the required rear yard setback to accommodate a proposed addition to the existing home on the subject property. Per the approved PD 84-0336, a minimum of 20-foot rear yard setback is required in the PD zoning district. The applicant is going to request a 5-foot variance to that 20-foot, resulting in a 15-foot rear yard setback. We have no additional findings.
All right, thank you. No questions for you. All right, applicant?
Good morning. David Higuera, a resident at 12827 Big Sur Drive. So we're seeking to add a bathroom to the back of the house, which is the best location. Adding a bathroom anywhere else will be detrimental. There is no other place to place it. The only other option will be to place it on this create a second story, which will completely require us to move out of our home. I do have, it won't interfere with anyone's view, which is what is required by the HOA. All the houses are fenced, and it will be attached. It will be right in line with the property. It will be, the neighbor to the right is okay with it. I do have an email from her if needed. And it almost looks like it's gonna be right to the same length as her house. And I have a couple pictures to show up if needed.
Okay. You can display the pictures on the overhead. Just, are they something that you can submit to the record today?
Yeah.
Okay.
I can send them via email.
I'm sorry, they're on your phone?
Yeah, I can send them via email to.
Is that?
I can put them in the overhead.
I don't think that's going to be allowed.
Okay,
no,
that's
sir.
fine.
It would have to have been submitted to the record already. But I do see your survey. And I can see your proposed addition is on the rear of the main structure, and it's right next to your pool. Is that correct?
Correct.
Okay. Is there anywhere, well, you've already testified that, just to clarify, there's nowhere else on your property where this could be built, right?
No. And also because where the sewer comes in, there is a bathroom on that wall right there on the side, so it is the only way to attach it. Otherwise, you have to tear the house in half to get through the sewer.
All right, so no other place the addition could be built, and you couldn't build it without the variance?
Correct.
Correct, okay. All right, sir, that's all my questions for you. Did you have anything further?
No.
All right, thank you. Be sure that you sign in with the clerk here. Thank you. All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, do not hear anyone. Development Services, anything further?
Nothing further, thank you.
All right, thank you. And Mr. Higuera, anything further, sir? No, okay, thank you. That will close the hearing on variance 24-1300.
Next item is item H8, variance 24-1320. The applicant is Farid Miha and Janet Miha Tripti. The request is a variance to lot development standards. Staff findings will be provided by James Baker.
Good morning.
James Baker Development Services, variance 241320. The applicant is requesting a variance to encroach into the required 15-foot side yard setback to construct a single-family home under Land Development Code Section 6.01.01. A minimum 15 side yard setback is required in the AS1 zoning district. The variance request is for 1.7 feet, resulting in 13.3 foot side yard setback. Our findings are that a non-conforming lot determination 24-0322 certified the parcel as a legal non-conforming lot pursuant to provisions of Land Development Code Section 11.03.03. The parcel is approximately 0.9 acres.
All right, thank you. No questions for you. All right, applicant?
Yeah, my name is, good morning, my name is Farid Mia. His address 9405 Zoe Bud Road, Sumner, Florida, 33584. I'm requesting for which side of my house as 20-inch variance.
All right, just to clarify then, you're building a house, right?
Yes, ma'am.
This is a new house.
Yes.
And you're requesting a variance for 1.7 feet?
Yes.
Your house will be 13.3 feet from the side yard, is that correct?
Yes, correct.
Okay. And why is that necessary?
Because we had a right because our poorer guy, he did a mistake. So when we did a slab survey, then we find out was wrong.
Okay. All right, so your builder essentially made an error and put your house just a little too far.
It's the homeowner builder permit, I pull it.
Okay, all right. And if the variance is not granted, what happens?
Tear him whole house.
Okay. All right. All right, anything further you wish to add?
No, ma'am.
Okay. All right, thank you. Be sure and sign in with the clerk here. Thank you, sir. All right, is there anyone here or online who wishes to speak in support of this application? All right, do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, do not hear anyone. Development services, and maybe I should have asked the planner. I understand the non-conforming is due to this being just under an acre, 0.9 acres. Was there anything non-conforming about the width of the property? And does it meet the, I guess the direct question, does it meet the minimum width for the zoning, or is that an issue too for them?
They're a little bit short on the width too. The requirement is 150 feet and they're 130 feet in width.
All right, thank you. All right. Was that anything further from Land Development Services?
Nothing further.
Okay. And applicant, did you have anything further you wish to add?
No.
That's a no. All right, thank you. This will close the hearing on variance 24-1320. Thank you.
Next item is item H9, variance 24-1343. The applicant is Alpesh Gandhi. The request is a variance to fence requirements. Staff findings will be provided by Isis Brown.
Good morning again, Isis Brown, Development Services, variance 24-1343. The applicant is requesting a variance to accommodate a proposed fence on a corner lot zoned PD 14-0126 per LDC with the, PD-140, 4-126 with the recent modification of PRS 15-0343. Per LDC Section 6.0702C.1.A, a minimum height requirement of 4 feet is allowed in the required front yard, except not in this certain circumstances. The applicant is requesting a 2-foot height increase on the corner lot as it has 2 front yards, resulting in a 6-foot high fence. The subject property is within parcel D of the set PD 14-0126, and there is a utility easement along the north property line running west to east, as you'll see on the site plan.
Okay. And so just to clarify, maximum fence height in the front yard is 4 feet?
Correct, yes, ma'am.
Okay. And the request is for 2 feet variance, so to have a 6-foot high fence, and that would be applicable along the north?
Correct, yes, ma'am.
And is there any issue with having a fence there because that utility easement is there?
No, we did let the applicant know that they will have to provide access to the utility company that has that easement running along.
Okay. All right, thank you.
All right.
All right, applicant?
Hey, good morning. Alpesh Gandhi, 18106 Pine Hammock Boulevard, Lutz, Florida, 33548. As Ms. Brown stated, the request is for the variance for the height requirement of the fence. The intended use of the property, of the area, is to add a playset for my children for privacy, safety purposes. It's a corner lot, so there is quite a bit of traffic. There was an attempted kidnapping directly across the street a couple of years ago as well, so safety and privacy are definitely paramount. We've also, several of the neighbors have requested speed bumps on the street due to heavy traffic and speeding concerns, but the HOA did deny, even though the county had approved and recommended it. Therefore, adding a fence and having a playset inside the fence so that my children aren't running outside is the intended use. In addition, there is no adjacent property on that side since it is a corner property, and it's not directly prohibiting any other neighbor or the community from any access or any view.
All right, thank you. I don't believe I have any questions for you. I have your survey. I've reviewed the request. So did you have anything further?
No, that'll be all.
All right, thank you.
Thank you, ma'am.
Be sure and sign in. All right, is there anyone here or online who wishes to speak in support of this application? All right, do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, do not hear anyone. Development Services, anything further?
Nothing further. Thank you.
All right. And Mr. Gandhi, anything further? Nothing? Okay. All right, this will close the hearing on variance 24-1343. We have 2 more cases. We're going to take a 5-minute recess. We have 3 more cases. We're going to take a 5-minute recess. We'll be back in 5 minutes. All right, if you would please take your seat, thank you. We're going to reconvene, and this is the Land Use Hearing Officer meeting for November 20, 2024, and we're ready to hear the next case.
Next item is item H10, variance 241355. The applicant is Dale Pachowick. The request is a variance to fence and wall requirements. Staff findings will be presented by Jared Folden.
Okay.
Good morning, Jared Folden with Development Services. This is variance 24-1355. It is a request to vary from maximum fence and wall height for a property located on 301 West Trapnell Road. This property is zoned AS-1. It fronts a, it's Trapnell, which is a major roadway. The request is looking to accommodate a 6-foot tall fence along the front yard and an 8-foot, sorry, it's a wall, my bad, and it's a 8-foot tall wall along the east property. And so the sections that are being varied from are 6.07.02.c.2. Typically in an agricultural district, unless there are no agricultural uses on the property, they will have to adhere to single-family residential standards, which is 4 feet along front yard and 6 feet along side yards or rear yards. Happy to answer any questions.
Just to clarify, and I'm looking at the drawing or the site plan in the record. Mm-hmm. This proposed 6-foot wall would be along the north property boundary, and then would it also extend down the east property boundary to the front yard distance?
And along the entire front is 6 feet, and then once it starts going south along the east, it is 8 foot.
It's proposed to be 8 feet there.
Yes.
But I mean, part of that is required front yard area, right?
Correct, yeah.
Okay. So part of this variance is 8 feet in the front yard area, isn't that right?
Yes, that is true, yes. So it is actually a 4-foot variance for front yard, yes.
Okay. Do we need that corrected on the staff report? Or in the application?
I believe we have it correctly on there. I just maybe stated it incorrectly.
All right, so, but just to be clear, the request is for a 6-foot high wall along the entire north boundary of the subject property and an 8-foot high wall along the entire east property boundary of the subject property.
Correct.
Okay, thank you very much. All right, applicant.
Dale Bioviak, 301 West Trapnell Road, Plant City. The elevation of my property is 2 foot lower than the road. So if you were standing on my property, an 8-foot wall, you're shorter than the elevation of the road. So a 6-foot wall up front will block out the scenery of the Trapnell Road. The 8-foot wall would block out the scenery from the State Road 39 on the east side. If my property elevation was up higher than the required 4-foot and 6-foot wall would be accommodated, which would be fine. To the east of me is vacant land. There used to be a row of trees, many trees that was chopped down 3 years ago. So I can see the traffic and the sounds of State Road 39. I'm trying to eliminate that. There's a makeshift shooting range on that property. They go out there and shoot sometimes. So I need to avoid the gunfire or maybe some safety issues.
All right. Do you know the distance, for example, of your north property boundary to the roadway? I guess
From my property line to the edge of the road north is about 15 feet.
Okay. My question there is related to, would such a tall wall interfere with any line of sight for the traffic on that road?
No, actually, I will still be able to see the top of the cars if I'm standing in my yard.
How much lower is your property from the roadway?
It's about 2 feet. My house was elevated when I built it in 98. So my house elevation and the road elevation is about the same. My property is lower.
I see. Okay.
And in my application, there's pictures and video and.
Yeah, okay, in the record?
Yes.
Okay. And then the property to the east of you, is it vacant now?
It's vacant. There's a parcel right next to me that's vacant. Somebody in Idaho owns it. And then there's a big parcel on the corner of Trapnell and 39 that is vacant. That's where the trees were that was blocking out the site of the road. Like I said, they removed the trees, and now it's just, you can see the road. I'm sure it's going to be developed commercially, in the future. And I'll have the sites of whatever's there. And
you mentioned someone uses one of those parcels for shooting. Is that the one on the corner, or is that the one adjacent to you?
The one on the corner.
On the corner.
Yes.
So the one adjacent to your property, abutting your property, is that a residential parcel?
I believe so, it is, yes.
Okay. All right. Anything further you wish to add?
I have nothing.
Okay. All right. Thank you. That's all my questions for you. Make sure you sign in with the clerk. Thank you. All right. Is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right. Do not hear anyone. Development Services, anything further?
Nothing further.
All right, thank you. And applicant, Mr. Is it Pichowiak? Is there anything further, sir? All right, thank you. That will close the hearing on variance 24-1355.
Next item is item H11, variance 24-1359. The applicant is Root Project Management Group, Ruth P. Lodondo. The request is a variance to lot development standards, variance to accessory dwelling requirements, and variance to fence requirements. Staff findings will be provided by Tanya Jabella.
Tanya Chapella with Development Services. The applicant is requesting variances to accommodate two existing structures, a principal dwelling and an accessory dwelling. And also, there is a variance to the maximum fence height within a front yard. So we have 5 variance requests. Per the Land Development Code, Section 61102A, a minimum lot area of 7,000 square feet is required for accessory dwellings. The applicant is requesting a 500 square feet variance to allow an accessory dwelling to remain on a 6,500 square foot lot. Second variance, per the Land Development Code, Section 61102 and 60101, the accessory dwelling shall meet principal building setbacks. The minimum front yard setback for property zone RC9 is 20 feet. The applicant is requesting 5.37 feet to accommodate, to allow a 14.63 foot front yard setback for the accessory dwelling and front yard functioning as a side yard. Variance 3, per the Land Development Code, Section 61102 and 60101, the accessory dwelling shall meet principal building setbacks. The minimum side yard setback for property zone RC9 is 5 feet. The applicant is requesting a variance, which is 0.48 feet, to allow a 4.52 foot side yard setback for the accessory dwelling. The fourth variance, per the Land Development Code, Section 60101, the minimum front yard setback for property zone RC9 is 20 feet. The applicant is requesting 9.9 feet to allow a 10.1 foot front yard setback, I'm sorry. And the last variance is to Section 60702, C1A, fences over 4 feet in height shall not be located within the required front yards, except under certain circumstances that are not applicable to this case. The applicant is requesting a 2 foot variance to allow a 6 foot high fence. And this concludes my presentation.
All right, Ms. Chapela, is the 2-foot increase to the fence height, is that on the front yard that functions as a side yard?
Yes.
Okay, and then the 9.9-foot variance to the front yard setback, is that for the primary structure? Or the principal structure, I should say?
Yes, it is the case.
Okay. All right, so there's a request for front yard setback for the principal structure and also a front yard setback for the accessory structure, and that is the front yard setback on the front yard that functions as a side yard.
Yes.
Okay, just want to make sure I understand all of them. Thank you.
Thank you.
All right, applicant?
Good morning. Ruy Londono, 1502 West Bush Boulevard, Tampa, Florida. Okay, I'm here in behalf of the owner, the property owner, Jose Malagon. The property is located on the Town and Country community that is north of Hillsborough Avenue, south of Slide, west to Manhattan Avenue, and east of Anderson Road. Okay, this is, we are requesting, like the planners say, 5 variances, 2 for the principal dwelling that was built. Okay, let me, before this one, to clarify that this is the parcel, the lot is a platted lot that was platted back on the 1959. That's the lot number 1 of the block 6. The size for that lot that was platted is 65 by 100. That is 6,500 square foot. The current zoning is RS 9. The minimum requirement for that lot is 500, but after we was talking about the accessory dwelling, I got to explain a little more about this one.
Okay. I'm sorry, back up. You said it's a platted lot. I understand it's an older plat, and it was a 6,500 square foot lot.
Yes.
And RSC 9 zoning, and the minimum
5,000.
5,000. Thank you. Okay.
That is like 500 more, 1,500 more than the land development code on that zoning request.
I understand. Thank you.
But let me say something else when I go to my accessory dwelling variance. Okay, let me go first to the principal dwelling. Okay, the principal dwelling was built back on 1953. That means that has been there for more than from 1963. This is a corner lot. When we was working on the variance, we found that the principal structure does not meet the requirement for the land development code. That is the reason that we are requesting 2 variances. One that is for the front yard that is acting as side yard. That is, the requirement is we need to meet 20 foot from front yard. The principal dwelling have 10.10. We are requesting to reduce from 20 to allow 10.10 foot on the front yard that is acting as side yard. Also, for the principal dwelling, we are requesting also a reduction from 20 to 10.45 feet. This is a structure that is attached, is a enclosed porch that is attached to the principal dwelling.
And I don't think I see that one in the staff report.
Yeah, that is the variance number 2 under principal dwelling. When you go to the, that is on the staff report.
Variance number 2 on the staff report says
No, I'm sorry. On my variance is the number 2. On the staff report is the number 4.
Okay, the 4th variance on the staff report is for 9.9 feet to allow a 10.1 foot front yard setback.
Okay, is the next one. That's for the front yard.
That's for the fence height. The next one is the fence height.
That is the one before. Okay.
I don't see that variance in the staff report.
Okay, but let me explain because it's on my request.
Okay, so then tell me what the variance is for.
Let me explain better in here. Can you look this one? Okay. Oh my goodness, I don't know how this works. Okay.
It's fine, just like that,
zoom.
yeah.
How can I go to zoom this one? Okay. This one in here is the principal structure. All this area in here is the house, and this part in here is the porch enclosure. The corner, on the southeast corner, we are requesting to reduce from 20 to
10.1, got that.
Okay, but when I go to the rear from the house, that is a porch enclosure, we need to reduce the set.
Okay, wait just a minute. Your microphone is, let staff adjust it, please. Thank you.
Okay, that's good. Okay, perfect. Thank you. Okay, when you go to the enclosed porch, that is the corner from the porch that we need to reduce from 20 to 10.46. 10.46.
All right, so that is the variance I don't see in the staff report at all. Is it part of the record?
But maybe
yeah, Ms. Chappella, could you come to the microphone, please? Thank you.
I'm going to try to address what I think is a confusion. So Ms. Londano is considering the porch, and she mentions it's an attached porch. It's an attached porch. Since it is attached to the main structure, that is part of the main structure. So we're working with the section of the code for main setbacks, 60101. We are not considering the regulations for the detached porch because it's over 10 or 13 feet to the rear setback, or in this case, it's no rear setback, it's a corner lot. So the section of the code for porch, I think it's 60103, if I'm not wrong, 60103I, if I'm not wrong, it's not applicable. So in this case, the main part of the house and the attached porch is one unit.
Okay, so I think I follow you. So the front part of the main house, that corner on, and I'm not looking at the directions. Yeah, there it is. It would be on the southeast corner of the house. It's 10.1 feet from the property line. So, and the northeast corner of the house, the main structure, is 10.46. So what the request is that larger variance, and that'll cover both.
It is correct. That's the case.
Okay. Thank you. I understand that now. All right, Ms. Lindano, did you understand that?
Yes, I understood.
Okay. Then let's proceed.
Okay. That is, if the first one got to cover also the enclosed porch, we are okay with that one because that's less variance, and that's got to cover all the structure for the principal dwelling. Okay. Let me go to the next request that is for the accessory dwelling. Okay, on the accessory dwelling, we have 3 requests, 3 variances. One for the front yard that is acting as side yard. And we are requesting from 20 to 5.26. Okay, the other one is on the side yard. The request is 5 foot, and we have 4.52. We are requesting to reduce from 5 to 4.52. And the other variance is the lot size. Even if this lot is more than 5,000 square feet, that is request per zoning, when you have an accessory dwelling, they have another requirement that the lot, even if that is on RSC 9 zoning, the lot must to have 7,000 square feet. We are 500 square feet less than the lot requirement. That is the other variance that we have, the variance number 3 that we have for the accessory dwelling. Okay. Now, the next variance is for the fence height. The fence height is located on the front yard that is acting as a side yard. We are requesting to increase from 4 feet to 6 feet height.
Okay, and that is just for the front yard on the east side of the property. So that's the front yard that is functioning as a side yard.
Correct, and it's only for the portion that is already on the property. That means that is like you. That is like a U because they have, the front yard is also 20. We need to reduce the 20 part or the length for the fence and the other 20 foot. Because all that area is request to be 4, and we are requesting to increase to 6.
Okay, I understand.
Okay, this they have the houses under a code enforcement violation only for the accessory dwelling. One time the variance we granted, we got to apply for building permit to an after-built permit. And everything got to be in compliance with the land development code requirements.
Okay. So when the existing property owner acquired this property, that accessory dwelling was not there, correct?
That was not there. That was only a small storage.
Okay. And so they constructed the accessory dwelling without permits?
In 2023, last year.
Okay.
They want to use that one for a member family, that is his daughter.
Okay.
I found another property on the area on Town Country. That is the variance number B24. Let me see. That was approved for accessory dwelling. Almost the similar condition, lot size, because it's on the same community, 6,500 square feet. Lot size, they reduced to the 500. That was accessory dwelling too. And also they approved for the setback requirements on that other variance that is on the same community.
Do you have that address, or?
Yes, I have the address and I have the variance number.
Okay, what was that?
The address is The variance number is 24-0038, and the address is 4537 Paris Street.
Paris? Okay. All right.
Okay, any other question? Also, I have letter support from the property owners. I have around 50%, little less, like 35% of the property owners that is, they have an affidavit that they have having support for the variance. I have the letters here. I got to leave for the record.
All right. Thank you. All right. Is there anyone here or online who wishes to speak in support of this application? I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? I do not hear anyone. Development Services, anything further?
Nothing further.
All right, thank you. And Ms. Londano, anything further? Okay, that's a no. This will close the hearing on variance 24-1359.
This brings us to section I, special uses. Item I1, special use 240439. The applicant is Hillsborough County. The request is a special use for a wireless communication facility. Tim Lampkin will provide staff findings after presentation by the applicant. Alexis Myers will be presenting Planning Commission findings virtually.
All right.
Hi, my name is Nick D'Amico. I'm with DataPath Wireless Group, 6415 DeVesta Loop, Palmetto, Florida. We are the authorized agent for Hillsborough County on the project. We are requesting variances for the co-location and where's my phone? There's another variance as well, I'm sorry. We're building a communications tower 120 feet to support public safety communications for Hillsborough County.
Okay. Let's see. It looks like you're requesting a variance to the camouflage requirement. Can you speak
Correct.
to that?
Yes, so typically camouflage towers are monopole type towers. And we're building a self-support for the proposed load of the tower. It's in record. We submitted a tower loading document. But the proposed load will provide is not allowing us to use a monopole tower. Our setbacks are very significant from the property line, and there's natural buffering in place also. It's a 583-acre parcel.
Okay. So this is not a monopole, right?
No, ma'am.
All right. What type of tower, what is it called other than monopole?
A self-support tower.
A self-support.
Yeah.
So is that the kind that looks kind of like lattice and it's?
Yes, that's
okay.
correct. Yeah.
All right.
Yes.
And those typically are not camouflaged?
No, ma'am.
All right. And is that type of tower required in this location for some reason?
Due to the loading,
okay,
or the proposed loading and future loading of the tower, yes.
All right. So monopole type with camouflage wouldn't work. Is that
correct?
All right. Okay. Then the other request was for a variance to the required co-location. Can you speak further on that? Why is that variance necessary?
Several reasons. It's only a 120-foot tower, so the county's load and future proposed loading, their growth doesn't leave a lot of space for co-location, and as well in the record, was a letter from Bill Hand, who's a Hillsborough County employee, and it stated that Hillsborough County would prefer not to allow other tenants on their tower, especially in this instance where we're behind the alternate emergency operations center. They would just rather not have other vendors behind there in their loading dock having to have 24-hour access to their equipment.
Okay. All right. So having other, I guess, non-county users on site would be less than desirable because this is a county...
Security risk.
Okay, security. Yeah. Thank you. All right. Is that it? Just the two?
That's right.
Variances? Okay. Anything further you wish to add?
No, ma'am.
All right. All right, thank you very much. Be sure and sign in with the clerk.
Thank you.
Thank you.
Good morning, Tim Lampkin, Hillsborough County. So this is the location of the Hillsborough County East Maintenance Complex, and it's proposed to be located towards the center of the 587-acre subject property. And it's an alternate location for the Hillsborough County's Emergency Operations Center for activations. Regarding the waivers, the applicant did submit justification, just summarizing the section 6.11.29.d.3.b, point 4. So the district does require camouflage structures. However, the applicant proposes, as they've stated, to waive that requirement due to its location right outside the back entrance of the public use facility warehouse and not being visible by line of sight from any of the surrounding properties. The other two waivers are interrelated. They have to do with the co-location. So it's shared use, section 611.29.g, and which requires notification, and 6.11.29f. And so because, and the applicant answered this, but so I'm kind of repeating a little bit, but essentially this tower is proposed to be an integral component of the sheriff's countywide communications network. And it was determined that the criminal justice related information which is being transmitted over the countywide network will include this proposed site. The transmission of this type of information must be in accordance with procedures outlined in criminal justice user agreement between the Florida Department of Law Enforcement and the Sheriff's Office. Based upon the agreement between FDLE and the Sheriff's Office, they're required to restrict access to their communications site to personnel who have completed a mandatory background investigation. Given these security restrictions for the Hillsborough County Sheriff's Office, staff has no objection to the proposed waivers. Staff does note that the location far exceeds the minimum setback requirements found in LDC, section 6.11.29.d.2. And the applicant submitted all other required information, including pursuant to LDC section 6.11.29.j regarding the Federal Aviation Authority did review the proposal as required by the airport zoning regulations. And based upon staff finds this approvable, there were no objections from any other review agencies, and that concludes my presentation, unless you had any questions.
Okay, just a quick one. There were two variance requests or three?
Three.
Okay, so one was the camouflage, the other was the co-location. What was the third one?
So the co-location requires you to send out notices.
Oh.
So we were just wanted to ensure that it included the notice requirement, which kind of becomes moot, but it is required. And so we're requesting that notice requirement, noticing potential users, be waived, and then the co-location, the letter of intent, be waived. So it's 6.11.29F and then 6.11.29G. They're interrelated.
Okay,
So
well, that makes sense. Thank you.
You're welcome.
All right. So, Planning Commission.
Alexis Myers, Planning Commission staff. The subject site is located in the quasi-public future land use category. It is in the urban service area and within the limits of the Tenoda SAS, not within the limits of any community plan. The proposed special use meets the intent of future land use element objective 1 and policy 1.4 on compatibility. It also meets the intent of objective 46 and policies 46.1 and 46.2 that require telecommunication towers and facilities to be in areas with compatible land uses and adhere to all local, state, and federal laws. Based upon those considerations, Planning Commission staff finds the proposed special use consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the proposed conditions by the Development Services Department.
All right, thank you. Okay, is there anyone here or online who wishes to speak in support of this application? All right, I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, do not hear anyone. Development Services, anything further?
Nothing further, thank you.
All right, thank you. And applicant, anything further? Nothing, okay. Thank you. That closes the hearing on special use CFW 24-0439. And that concludes the Land Use Hearing Officer meeting for today.